it is imperative to address the Nigerian people on the deliberate mischief and puerile propaganda of Senator David Mark and his co-travelers parading themselves as coalition politicians at the ignoble press conference held on Thursday, 2 April 2026. The highlights of their press conference, shorn of the unwarranted verbal vituperations, are as follows, so that we can set the context of our response. What did they say in their press conference? One, they claim President Bola Tinubu is deliberately weakening opposition party to force a one-party state ahead of 2027. They also contended that INEC acted unlawfully by withdrawing recognition of their leadership, misinterpreting the Court of Appeals order that status quo ante bellum should be maintained, and thereby they were calling that, saying that INEC has taken side against them. They also accused INEC of partisanship and contempt of courts. At the same time, they were calling for removal of not only INEC chairman, they were calling for the removal of all INEC commissioners. They also insisted that they will go on with their scheduled activities in terms of congresses and the convention, despite the pending litigation and the orders of the Court of Appeal that status quo should be maintained. Of course, their usual refrain, they say they are warning Nigerians and international community of a looming threat to democracy. Very laughable. Anytime they lose in case, democracy is in danger. But when our party are losing in court, they will say democracy is alive. We find it pertinent and imperative to interrogate these allegations dispassionately and lay bare the facts of the matters at stake, with a view to not only to show the falsehood being peddled by David Mark and his co-travelers, but to enlighten Nigerians and the international community about the unserious nature of the so-called opposition coalition. One, we first address the first issue. They claim that President Tinubu is weakening opposition to force a one-party ahead of the 2027 election. It seems David Mark and his co-traveler were not aware that as of today, there are 19 registered political parties in Nigeria, with all of them having potential to compete in the 2027 election. And President Bola Ahmed Tinubu, by law, under the Constitution, has no power to deregister or to meddle into affairs of any political party. You lay your bed and you sleep on it as you have laid it. Nigerians must know that the present predicament of David Mark and his ilk has to do with the untidy way they hijack the leadership of an existing political party without carrying along all stakeholders, resulting in court litigation before the Federal High Court, and the adverse judgment of the Court of Appeal, upon which the INEC predicated its decision not to recognize any of the two contending parties for the leadership of the African Democratic Congress, pending determination of the pending suit at the Federal High Court. So it is not Bola Tinubu, President Bola Tinubu, that went to courts, or that also went to Court of Appeal. It was David Mark, and his appeal was dismissed. So to now lay your failure at the court, at the doorstep of the president, show that you are either a liar or something is obviously wrong with you in terms of mental articulation. The ADC of Mark went to Court of Appeal over an internal leadership dispute that was still ongoing at trial court. A case was still going at trial court. They rushed to the Court of Appeal, and in doing so, made a fundamental legal mistake. And I enjoin journalists who are fast at reading to read the copy of the judgment of the Court of Appeal. They showed them that they are not serious. They did not seek leave to appeal. A decision has not been taken. They appeal. They were contending jurisdiction at the Court of Appeal at the same time at the High Court, which shows abuse of court process. And in doing so, they made fundamental legal mistake. That mistake cannot be laid at the doorstep of President Bola Ahmed Tinubu or our party. The appellate court found that the lower court had not granted injunctive relief sought, but merely asked the defendant to show cause why the order sought should not be granted, implicating that Senator David Mark's faction appeal was built on a faulty premise. What happened from the judgment of the Court of Appeal was that there was an order, there was an application for other ex parte that they should be restrained from parading themselves as leaders. Justice Nwite of the Federal High Court did not grant the order yet. He said, come and show cause where the order should not be granted. Rather than going to show cause where the order should not be granted, they rushed to the Court of Appeal to say that the Federal High Court has no jurisdiction and also appealing an order that had not been granted. So the Court of Appeal clearly, categorically stated that one, the issue of jurisdiction cannot be litigated freshly at the Court of Appeal, particularly when you have filed a notice of objection on jurisdiction at the Federal High Court. Secondly, because the order to show cause was an exercise of discretion, you need the leave of the Court of Appeal, and their lawyer did not seek any leave, and therefore the case was dismissed, and cost of 2 million naira was awarded against them. The cost also awarded by President Bola Tinubu or the APC. What still? The key issue of jurisdiction was still pending at the trial court as we speak, making the appeal premature. And they failed to obtain the required leave for an interlocutory appeal, an error serious enough to render the entire case incompetent. So their case was declared to be incompetent and dismissed by the Court of Appeal on those two grounds. One, they did not seek leave. At the same time, they were litigating issue of jurisdiction at both courts. So if they are incompetent politicians who have also hired incompetent politicians, that should not be at the doorstep of President Bola Ahmed Tinubu or the APC. The appeal was consequently, therefore, dismissed completely by the Court of Appeal, and the Court of Appeal made consequential order. The Court of Appeal made order to maintain status quo and avoid any action that could disrupt the ongoing case effectively, portraying the ADC as acting hastily, procedurally flawed, and in regard of due legal process. So what it showed is that they acted hastily by going to the Court of Appeal. They also did not follow due legal process and actually disregard actual legal process. For the avoidance of doubt, in dismissing an appeal filed by David Mark, the Court of Appeal made the following orders, and it's clear on the face of the judgment of the Court of Appeal. One, that suit number FCT ABJ 1819/2025B and is hereby granted accelerated hearing in view of the electoral timetable released by the fourth respondent. So the Court of Appeal was mindful in remitting the case back that there was a timetable and that the case should be heard timeously and granted accelerated hearing. But of course, you will see that they are not ready to get accelerated hearing by going to the press to already conduct their case and giving themselves judgment at the press conference. Two, that the parties are hereby directed, not my language, language of Court of Appeal, to maintain status quo ante bellum, that is status quo before hostility, before any problem arose that led to the litigation in the case, and shall refrain, mark my word, Court of Appeal is saying this, refrain from taking any step or doing any act capable of foisting a fait accompli on the court or otherwise ready nugatory the proceeding before the trial court. I will get to this when I address the issue of their defiance and their attitude to disregard the court order and also the position of INEC. A cost of 2 million naira is awarded in favor of the first respondent. I wouldn't know whether they have even paid that cost now. So there may be in contempt of court if they have not paid the cost. It is the above orders, clearly, categorically, that is being put into effect by the Independent National Electoral Commission. And we are at loss the basis for the allegation that President Bola Ahmed Tinubu or our party, the APC, is weakening opposition in this circumstance. David Mark and his faction approached the Court of Appeal, and the appeal was dismissed as unmeritorious. Status quo was ordered to be maintained and costs awarded against them. In the circumstance, where does President Bola Tinubu features in their predicament, if not outright fallacious and malicious propaganda? The David Mark factional ADC leadership appear to also be indulging in self-delusion by positioning themselves as the leading opposition. You know, they were claiming yesterday as leading opposition, they were being crippled. I think it's act of self-delusion, and you see the reason. When their recent electoral outings clearly suggest otherwise. Since the so-called coalition of confusion came into being last year, we have had at least 3 sets of elections. We had election August 16, the by-election in 17 constituency. PDP won 1, ABGA won 2, NNPP won 1, APC won all the remaining 13. ADC did not get anything. Recently, at the FCT area council election, 6 local government councils were on offer. They did not win anything. 62 councillorship positions was on offer. They did not win anything. Then, on that same day, 2 by-election was conducted, each in Rivers and Kano State. They did not win anything. So, what's the leading opposition? What barometer are you calling yourself leading opposition that we are going to be losing any wink over? Gentlemen of the press, you cannot lay claim to national relevance while your performance at the post remains abysmal and unconvincing like that of the factional leadership of the ADC. Since the inception of their so-called coalition of confusion, they have been proudly rejected at the post by Nigerians, including during the recently held local government area council election held in the federal capital territory. A party that cannot produce 1 councillor out of 62 in FCT and say there's a leading opposition. Where is the opposition? Leadership of the opposition is not declared through press conference. You cannot just say, I'm leader of opposition, I'm leader of opposition through press conference or rhetoric. It is earned through consistent electoral credibility and public trust, both of which they have struggled to demonstrate. They don't have public trust, they don't have electoral viability, they don't have electoral acceptability. So it is engaging in self-delusion for David Mark and his co-traveler to be saying they are leading opposition and therefore APC is afraid of them. We are afraid. All the elections you have done and we have met, you have not even shown. Absolutely. And even when you look at the quantum of votes that they garner is so so low that even they are not. They ordinarily INEC should deregister them because they are just wasting the time of Nigerian people. Therefore, President Bola Tinubu and indeed our party, the All Progressive Congress, cannot be bothered about the contraption of electoral unviability being bandied as coalition. Even the word coalition itself shows confusion. Any student of political science will know that coalition means 2 or 3 or 4 political parties coming together, still maintaining their structure, but working in collaboration. You cannot go and hijack a political party on the same day that you join political party, become chairman, national secretary, and then you said Bola Tinubu is your problem, APC is your problem. You have decided to go and steal a Tokubo vehicle. So if the vehicle does have brain box problem, then you cannot blame us in that regard. Then the next issue, the purported misinterpretation of the Court of Appeal decision by INEC and alleged bias of INEC. This is preposterous. The factional leadership of ADC, which are the orders being implemented by INEC, was a consequence, as I mentioned, of the dismissal of an appeal filed by Senator David Mark. They lost at the Court of Appeal. They were not mentioning that yesterday. They are only in Yoruba language. They call something Ekun Egbere. You know, there is one norm that they always cry around. They are just crying Ekun Egbere around. They did not mention that they lost at the Court of Appeal. They lost the Court of Appeal. The decision being implemented by Independent Electoral Commission was as consequence of dismissal of an appeal filed by Senator David Mark and his faction at the Court of Appeal, where the decision did not go in their favor, but rather the Court of Appeal upheld the position of the respondent. The person they were calling impostors was the one that succeeded at the Court of Appeal. If Senator Mark and his factional ADC leadership believe INEC's interpretation is flawed, because they were alleging INEC ought not to have taken that position, if they really genuinely believe, they ought to know the proper channel to seek redress. It is to go to court, no press conference, no banalizing and demonizing INEC. If you know INEC has interpreted the decision wrongly, you go to the court back for proper interpretation. Absolutely. On his part, INEC has categorically stated that it is acting in line with maintaining the status quo ante bellum as directed by the Court of Appeal. So the arbiter in this case is not press conference, is not by the Ekun Egbere that they are doing. It is by going back to the court and get proper legal advice. And also, when you also look at what they were doing the act of public defiance. The public defiance posture of Senator Mark and his factional ADC leadership against orders of the Court of Appeal and the implementation by INEC not only amount to self-help, which is frowned at law, but recklessness and a clear display of gross irresponsibility. More concerning is their posture toward the International Electoral Commission and the rule of law. They are not even ready to obey the rule of law to maintain status quo. There was a dispute as to your leadership. The case is still before the Federal Court, and you still want to go ahead and conduct congresses and convention. Does that look like people who even have respect for rule of law and democracy? Insisting on proceeding with party congresses despite an ongoing case at the Federal Court challenging their leadership raises serious concerns about their respect for legal processes. Such defiance signals a troubling disregard for institutions and due process, undermining any claim to democratic responsibility. Their call for the sack of INEC chairman and other INEC commissioners, they don't even want to sack, they want to sack the entire INEC. Maybe they want to go and set up their own INEC. Assuming the INEC, all of them even were removed today or they resigned today, who is going to appoint another one? So if another INEC is also appointed again in line with the constitution by the president, you also ask them to sack. I think they are not ready for election. Their call for the sack of INEC chairman and other INEC commissioners further exposes a lack of seriousness and understanding of leadership processes of established institutions by the ilk of Senator Mark. As experienced politicians, ostensibly, and former public office holders, even though they did not do well when we were public office holders, they ought to know the constitutional process governing appointment and tenure within INEC, and that decisions are taken by the commission, not the chairman alone. And when they read what INEC put out, it said commission met and took a decision. It is preposterous that this undemocratic element have the audacity to call for the removal of not only the INEC chairman but the entire national commissioners. When I read the press conference, I was looking at the Samson story in the Bible that want to put down, the entire building over his head because he's going to die. So we cannot collapse institutions because you are not doing well in what you are doing. Then the other issue they raise is that the insistence to proceed with planned congresses and convention in defiance of the Court of Appeal orders and pending litigation at the Federal High Court. Nigerians should also note that the SAC David Mark's leadership of the ADC has insisted on proceeding with its scheduled activities, including congresses and convention, despite an ongoing case at the Federal High Court challenging their leadership and in defiance of the subsisting judgment. This again raises serious questions about their respect for legal processes and the rule of law. There were parties at the case pending, and here you say you want to go ahead. Do they have respect for rule of law? Do they have respect for judicial processes? It is settled law that court decisions are binding on all parties until set aside by a court of competent jurisdiction. The foul refusal by Senator Mark and his co-travelers to comply with court decisions demonstrates a troubling disregard for the rule of law and democratic responsibility, making those bold assertions that he was making yesterday of defiance to judicial processes and national decisions, despite the clear legal implications that all parties must maintain status quo to avoid foisting fait accompli in the ongoing proceedings at the trial court, show clear desperation and absence of democratic and rule of law credentials by David Mark and his factional ADC leadership. Indeed, their initial resort to interlocutory appeal appears to have been a clumsy, hasty, and a flawed procedural attempt to stop proceedings at the trial court, undertaken in disregard of due legal process. Gentlemen of the press, the public should therefore be aware that the defiant actions being pursued by David Mark-led factional leadership of ADC amounts to illegality, and when those actions are eventually declared null and void by the courts, it will be disingenuous to blame President Bola Tinubu and the ruling party for the consequences of their own disregard for the rule of law. We hope that they will not come to tell Nigerians, when eventually their illegality came to haunt them, that it is the APC or President Bola Tinubu that is weakening democracy when they meet the consequences of their planned illegality. They said they want to go ahead with congresses, they want to go ahead with convention, despite the existing case before the Federal Court, despite the decision of INEC to maintain status quo. We wish them well, but after they meet up with the consequences of their illegality, they should not come and say it is President Bola Ahmed Tinubu, son of Abiba Mogaji, that is creating problem for them, or Felix Moka party that is creating problem for them. Look inward and stop figure pointing. So our message to David Mark and his group of coalition of confusion is that they should look inward and stop figure pointing. The ADC faction must also come to terms with